Now I'm going to go ahead and share my screen with you. As long as I can get to the right screen.
I can see your recording. There's like a recording.
Do what?
There's a button next to your name now that says you're recording.
Isn't that fancy?
Super fancy.
Okay. Okay, so welcome everybody again. Thanks for your input on my husband's birthday gift. Again, please feel free to send me any other ideas you can come up with. So this is our April webinar meeting. It is a little unique that we would do a webinar plus a face-to-face. I'm hoping this is only going to go an hour, but bear with us if it goes a little bit over. It shouldn't, but it very well may. So today we're going to talk about, we got our feedback from our audit, hence the reason we're having an April webinar. And some things we need to address based on those results. We have to talk about prior written notice, MDR, where we still struggle as a district, some further documentation. We do have a video we're actually going to have you all watch during this webinar. It's like 20 to 25 minutes, but it gives some great information that can be used. And then, of course, as always, we have some additional information. So just to start, we did get our letter back from the State Department in terms of our general audit that occurred last fall. So overall, we're good. We did complete our the corrective actions as we were told. You guys are looking at your charters for your staff certifications. We did our PD on IEP development. Our IEPs have come a long way. We're doing much better present levels, impact statements, findings. Our goals are measurable. Post-secondary goals and transition are looking better. And then we are overall adequately describing the LRE. Our prior written notice still needs a little bit of work. So we're going to talk about that. The only area, so we've cleared everything from our audit and our corrective actions with the exception of one area, and we did not meet the requirements for submitting compliant IEPs and supporting documentation for following procedures when a disciplinary action involved a potential change in placement. So we are still struggling as a district with discipline, and when we're talking about students where it's may potentially be a change in placement. And we'll get into that here in a few minutes. So our prior written notice, some things that we want to talk about. First of all, do not ever copy and paste from another student's PWN. There were situations which the state saw where it definitely appeared that the PWN was either copied or there was definitely a great template and kids' names were just inserted and things like that. So that's a big no-no. Remember, it's totally individualized. When you're doing the PWN, and I know we've talked about this before, but we still have to make this a little cleaner. So when you're describing that action or proposal, don't just say, we held an annual review and proposed the IEP. Be specific about what the team is proposing within the IEP. We're proposing 60 minutes a day of services in the area of reading. Be very specific in what you're either proposing or refusing to do. You can bullet on this, but it needs to be specific. Don't just say, we held the annual review, we reviewed present levels, goals and objectives, accommodations, testing, blah, blah, blah. Don't just list it. Tell us what you actually proposed or rejected. For every proposal, in the next one, explain why the district agency proposes or refuses. There has to be a reason why you propose that. We don't want to just say, which I've seen, because they are entitled to an annual review IEP and the previous IEP expires. It's not good enough. So it's going to be, goes back to that detail. For every proposal, there has to be, or refusal, there is a reason why you proposed it or a refusal why. Because the IEP expires is not a good enough reason. The other options, there are always other options. Do not leave it blank or put NA or none at this time. Right? You always have the option of the team considering not to provide services. Perhaps you were talking about a homebound situation and the team decided against the homebound. Whatever. What were the other options of things decided? Make sure you have answers there. Describe the evaluation. Again, list here what data the team used to make their recommendations. Are you looking at Progress Modern data? Are you looking at Brigance? Are you looking at CBM, benchmark, MAP scores, teacher input, parent input, everything that you use to make those determinations and those recommendations for those IEPs. For other factors, don't just say previous IEP goals. Describe the other factors. Did the team discuss anything else? Like, have there been medication changes? Were there situations at home? I just did a meeting here where one of the things we discussed was just potential full-time medical homebound. So that was an option or another factor that the team has discussed. And I apologize on this PowerPoint. So don't just say previous IEP goals, actually goes with evaluation procedures. I didn't put another bullet. So don't just say that, you know, when you're looking at the evaluations, hey, we just looked at the IEP goals and that's it. And then, you know, when you're doing other options, what other things may be impacting the student, okay? So what things are happening either in home or in school that may be impacting that student. The agencies, as you know, when you hit the text assist, not hot, when you hit the text assist button, the agencies pull up, and I manage that at our level. So you wouldn't ever have to put agencies in. So really the MDR is we need to be more specific in what, not MDR, the PWN, we really need to be more specific in what we're doing. No generics. So our MDRs, our manifestations, where are we still struggling? Honestly, overall, with the process of discipline and MDRs, we as a district are doing well. We're notifying parents, we're holding meetings, we're doing those things. Where we are missing the boat is the post-MDR IEP changes. So when teams are at meetings, they're holding an MDR, they're not going to that IEP and making any changes after the MDR. So we're just holding MDRs and that's it, and no changes are being made to the IEP. We're seeing situations where FBA and BIPs aren't completed, and then that behavior is not addressed in a pre or post IEP. So if you're having an MDR and the student is up for expulsion or suspension because of discipline, and there is no discipline in the IEP pre or post, that's a red flag. There should be. If an FBA or BIP hasn't been completed, it needs to be done. So like I said, where we're missing that boat is those post MDR changes. So after the MDR, you guys need to review the current IEP and amend and make changes. Like I said, if a behavior is not in a pre-IEP and then the MDR, it would be highly recommended it be added post-MDR IEP, including potential goals. If no FBA or BIP has been completed or has been a long time, and the MDR team is meeting, part of the post process should include an FBA and a BIP. Be sure that behavior information is written and updated in present levels, findings and goals, special factors. Clearly, if a student is at multiple days suspension, behavior is impacting them in the classroom. And just as an example, we've seen some goals that the student will receive no more referrals. That is not a measurable goal. Remember, it's skill-based. But that was the state's biggest issue, is that we are not making changes to those IEPs after the MDR. The other area that we're struggling is if we are suspending or a student is going on home base, teams are not coming back together to change that IEP when they return to school. So those are the steps that we're missing. So what do we need? So based on the OSIS review, we obviously haven't been completely cleared of all our corrective actions. Therefore, by June 30th, we must submit 3 additional IEPs directly involving behavior and MDRs. So any of your students that will be going through an MDR, please let Susan or I know, and we can assist with guidance, because those will be ones that we will probably send to the state. These are not kids that we've already submitted. They want 3 brand new students. We are making the assumption in the next few months, can almost guarantee we'll have at least 3 MDRs held in this district in the next couple of months. So don't call us after the fact that you've held the MDR. Call us before. Let us help you brainstorm. Let us help you walk through it so we can make sure we have the right documentation, we're doing this process right, and we can move forward with submitting this stuff to the state and then get a final clearance letter and be done with this audit finally. Oh, the secret word is referral. Dun, 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 dun. Pretty fitting. Okay, so now we're going to watch this video. Like I said, it's about 25 minutes. Please stay on and watch this. It is going to deal with legal issues when disciplining students with disabilities. You will see that it has a course number. It's actually a video I watched as part of my SPED law class and got permission to share it. Susan and I both thought it was very beneficial. You can share this with others if you feel that it will be beneficial to you all too. Can you all see that? Susan, can you see that?
Yes.
Okay, thanks. So I'm going to play it and be quiet.
Perhaps the most confusing and disturbing issue that arises under the IDEA is that of discipline, or more specifically, the use of suspension and expulsion with students with disabilities. This video is designed to provide a general overview of the rules of suspension applicable to students with disabilities under the IDEA. To review the disciplinary provisions in detail could typically take a full day, and this video is designed to provide you only with the fundamentals in a short period of time. Let's use a hypothetical to set up our discussion. An assistant principal walks into the bathroom of the middle school and finds two students smoking marijuana. The assistant principal escorts them both back to the principal's office where the police are called. The principal is informed that one of the students involved is in special education and has already been suspended on 3 separate occasions during the year, for a total of 20 cumulative days already. In addition to out-of-school suspensions, the student has been suspended from the bus on 2 other occasions and is currently in-school suspension. The other student is in regular education and is immediately sent home, and expulsion is recommended. With respect to the student with a disability, the following questions arise in our hypothetical. Can the principal immediately remove the student from school? Can the student with a disability be further suspended from school? And if so, what procedures must be followed? Do the previous bus suspensions and in-school suspensions affect the principal's ability to further suspend the student with a disability? Was the IDEA violated when the assistant principal called the police? The rules regarding suspension and expulsion that apply to the regular education student clearly do not apply to the student who is receiving special education. For that reason, I've developed 13 general rules of discipline that apply to the student who has been identified as a student with a disability. Let's first review those rules, and then we'll return to our hypothetical and answer the questions posed. Rule number 1. All students, disabled and non-disabled, are entitled to certain rights before they can be excluded from public school for any period of time for disciplinary reasons. Rule number 1 applies to both non-disabled and disabled students and stems from a Supreme Court case decided in 1975 called Goss versus Lopez. According to the court, education is essentially a property right that can't be removed without affording a student appropriate due process procedures. And the level of due process depends upon how long the student will be removed from school. For suspensions of 10 days or less, the court held that students are entitled to oral or written notice of the charges against them, and they're entitled to present their side of the story. For those short-term suspensions, this is usually done in the office of the school disciplinarian on an informal basis. With respect to suspensions for more than 10 days, however, the Supreme Court held that more formal procedures are required. For instance, the student is entitled to a formal hearing with the opportunity to be represented by a lawyer and the opportunity to confront and cross-examine witnesses. These requirements are generally fulfilled by a committee or a hearing officer responsible for convening and holding formal hearings for offenses that could result in a long-term suspension. In fact, some school boards may even preside over these discipline hearings themselves. Rule number 1 is the only rule that applies to the non-disabled student. There are 12 more rules that apply to students with disabilities. So let's look at those. Rule number 2. School personnel may consider any unique circumstances on a case-by-case basis when determining whether to order a change in placement for a student with a disability who violates a code of student conduct. The 2004 IDEA includes strange language that provides that school personnel can consider any unique circumstances on a case-by-case basis when determining whether to order a change in placement for a child with a disability who violates the code of conduct. Without anything more, no one really knows what this means, but what it says. Of course, when asking questions about appropriate discipline, the focus should always be on whether imposing a disciplinary consequence will constitute a change in placement for the student with a disability. We're going to address what constitutes a disciplinary change in placement in just a moment. Rule number 3, school personnel may remove a student with a disability who violates the code of conduct from the current placement to an appropriate interim alternative educational setting, another setting, or suspension for not more than 10 school days. The IDEA provides that school personnel, rather than the IEP team, may remove a child with a disability who violates a code of student conduct from their current placement to an appropriate interim alternative educational setting, another setting, or suspension for not more than 10 school days, to the extent that such alternatives are applied, of course, to non-disabled children. What Congress left unanswered, obviously, is whether this means 10 school days per incident, at a time, or cumulatively in a school year. Congress left this up to the U.S. Department of Education and left it to the regulations to define what removals constitute a change of placement. So let's look at what constitutes a change of placement under the regulations. Rule number 4, any disciplinary removal of a disabled student from the current placement for more than 10 consecutive school days is a, quote, change of placement for that student. Perhaps the heart of the discipline rules begins with rule number 4, this rule. And this rule forces us to keep in mind that certain suspensions can amount to a change in placement for a student with a disability. For that reason, we must always ask whether a particular disciplinary removal is going to constitute a change in placement for the student. This is so because there are procedural hoops that we must jump through if and when disciplinary changes in placement have occurred. The IDEA regulations provide that for purposes of removals of a child with a disability from the child's current educational placement, a change of placement occurs if the removal is for more than 10 consecutive school days. This does not mean that a child with a disability cannot be removed for more than 10 consecutive school days. What it does mean, however, is that such a removal cannot occur without following proper procedures or jumping through certain hoops. And we're going to discuss what those procedural hoops are. Okay, so we know that a removal from the current placement for more than 10 school days at a time, or 2 school weeks, is a change of placement. What about suspensions for more than 10 school days in a school year? That's rule number 5. Disciplinary removals of a disabled student for more than 10 days total in a school year might be a change of placement for the student, depending upon the pattern of the removals. Clearly, disciplinary removals of a disabled student for more than 10 school days cumulatively in a school year can be considered a change of placement for that student, according to the IDEA regulations. Specifically, the regulations indicate that removals totaling more than 10 school days in a school year might be considered a change of placement, depending on the pattern of those removals. More specifically, and for purposes of removals of a child with a disability from the child's current educational placement, the regulations provide that a change of placement occurs if the child has been subjected to a series of removals that constitute a pattern because the series of removals total more than 10 school days in a school year, because the child's behavior is substantially similar to the child's behavior in previous incidents that resulted in the series of the removals, and because of such additional factors as the length of each removal, the total amount of time the child's been removed, and the proximity of the removals to one another. So does that clear it up for you? Okay, in any event, the regulations require educators to look at the pattern of short-term removals over the course of the school year and determine whether the pattern, in conjunction with additional suspensions contemplated, constitutes a change of placement. Because this pattern of removals language is not clear and there are no clear guidelines attached, most states and school systems have decided that they will treat any removal for more than 10 school days in a school year as a change of placement and follow the change of placement rules when removing for the 11th day and so on in the school year. Keep in mind that we are still talking only about what suspensions or other removals will constitute a change of placement for a student with a disability. This does not mean that students with disabilities cannot be suspended for more than 10 days in a school year. Rather, it means that if suspensions go beyond 10 days in a school year and a change of placement will occur, appropriate procedures must be followed. We have one more rule related to what constitutes a disciplinary change of placement. Rule number 6. Disciplinary removals of a disabled student that are not necessarily called suspension may likely still be counted as change of placement days. It is important to be aware that there are some removals from school that aren't technically called short-term suspension, but are in reality the same thing. For example, in one case, the school put the child on what it called short-term suspension, but didn't let her know when she could come back. Other actions, such as insisting that a student be kept home for what's called home timeout, cool-off period, may be considered the same thing as a short-term suspension. Similarly, sending a student home early every day may count toward the change in placement days for a student with a disability. In addition, saying things like, "Don't come back without your Ritalin," is a violation of the 2004 IDEA, as well as a potential change of placement. All right, so we've addressed what disciplinary removals will constitute a change of placement for a student with a disability. So what does that actually mean? What procedural hurdles must be overcome in order to make a disciplinary change of placement? Rule number 7, within 10 days of a decision to make a disciplinary change of placement, a manifestation determination must be made. Though the IDEA didn't even mention the requirement to conduct a manifestation determination until 1997, it has always been the rule that school districts could not remove students with disabilities from their educational programs on the basis of behavior that was caused by or a manifestation of their disability. To do so would constitute discrimination. Thus, if a student misbehaves in school because of his or her disability, you can't exclude the student on that basis. Because of this rule, school authorities, through the student's IEP team, are required to make very difficult determinations as to whether a particular behavioral incident was a manifestation of the student's disability. Only where it's determined that the student's behavior was not a manifestation of disability may school officials change the student's placement. Specifically, the law provides that within 10 school days of any decision to change the placement of a child with a disability because of a violation of the Code of Conduct, the local education agency, the parent, and relevant members of the IEP team, as determined by the parent and the LEA, shall review all relevant information in the student's file, including the child's IEP, any teacher observations, and any relevant information provided by the parents to determine the following. Number 1, if the conduct in question was caused by or had a direct and substantial relationship to the child's disability, or number 2, if the conduct in question was the direct result of the LEA's failure to implement the IEP. If the LEA, the parent, and relevant members of the IEP team determine that either of those is applicable to the child, the conduct shall be determined to be a manifestation of disability. In addition, the 2006 IDEA regulations provide that if the LEA, the parent, and members of the child's IEP team determined that the child's behavior was the direct result of the LEA's failure to implement the child's IEP, the LEA must take immediate steps to remedy those deficiencies. So, the manifestation determination is the first procedural hoop for making a disciplinary change of placement. There are others. Rule number 8. Where the student's behavior is found to be a manifestation, the IEP team shall ensure that an FBA and a BIP are done and return the student to the placement from which the student was removed, unless the parent and the LEA agreed to a change of placement. If manifestation is found, the IEP team must do what I call the FUBA and the BIP stuff. That is, conduct a functional behavioral assessment and implement a behavior intervention plan for the student if one hasn't already been conducted. Where a BIP has already been developed, the team must review the BIP and modify it as necessary to address the behavior. Importantly, the IEP team must also return the child to the placement from which the child was removed, unless the parent and the LEA agree to a change of placement as part of the modification of the BIP. Well, what if no manifestation is found? Rule number 9. Even where no manifestation is found and placement is changed, the student still must continue to receive FAPE, and if appropriate, a FUBA and a BIP must be done. The IDEA provides that a child with a disability who is removed from the current placement where no manifestation was found, the student still must continue to receive educational services that will enable the child to continue to participate in the general education curriculum, although in another setting, and to progress toward meeting the goals set out in the child's IEP. Also, the child must receive, as appropriate, a functional behavioral assessment and behavioral intervention services and modifications that are designed to address the behavior violation so that it does not reoccur. Because of this provision, there's really no such thing as true suspension or expulsion of a student with a disability. Perhaps the biggest question that's left unanswered is what kind of educational services we're talking about here for the student who is removed and no manifestation was found. Note too that the 2004 IDEA only requires the FUBA and the BIP stuff as appropriate, and it's no longer a requirement in every single case where no manifestation was found. Okay, so the proper procedural hurdles for changing a student's placement are the manifestation determination and the FUBA and the BIP requirements. Are there any special rules for dangerous or disruptive students? Rule number 10. School personnel may remove a student to an interim alternative educational setting for not more than 45 school days without regard to manifestation in cases involving weapons, drugs, or serious bodily injury. In an effort to provide some relief to schools, the IDEA provides for special circumstances and allows school personnel to remove a student to an interim alternative educational setting for not more than 45 school days. It used to be calendar days. And this is whether or not the behavior is determined to be a manifestation of the student's disability. This 45-day removal can be used in cases where a child either, number one, carries or possesses a weapon to or at school, on school premises, or to or at a school function under the jurisdiction of the state or local education agency. Number two, knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substance while at school, on school premises, or at a school function under the jurisdiction of the state or local education agency. Or number three, where the student has inflicted serious bodily injury on another person while at school, on school premises, or at a school function under the jurisdiction of the state or local education agency. The IDEA references federal definitions of weapon, drugs, and serious bodily injury that must be used rather than what your state law may provide. I want to make it clear that in situations involving weapons, drugs, or serious bodily injury, the 45-day removal is all that school personnel can impose. But an IEP team may decide that the student should be moved to the anti-drug class at the alternative school for a year, and the IEP team can do so. If that is the decision of the IEP team, the placement could be changed via that avenue rather than through the disciplinary process. The 45-day option is something to be used that it's immediate and gives the IEP team the time to get together and meet and make those appropriate recommendations. What if a parent disagrees with a disciplinary determination? That leads us to rule number 11. A parent who disagrees with a disciplinary decision or an LEA that believes that maintaining the current placement of the child is substantially likely to result in injury may request an expedited hearing. The IDEA specifically provides that a parent of a child with a disability who disagrees with any decision regarding either placement or the manifestation determination, or an LEA that believes that maintaining the current placement is substantially likely to result in injury to the child or others, either may request an expedited due process hearing. When such a hearing is requested, the state or local education agency shall arrange for the expedited hearing, which must occur within 20 school days of the date the hearing is requested and result in a determination within 10 school days after the hearing. Under the IDEA regulations, timelines for things like the resolution meeting in these cases have been shortened as well to fit within the shorter time frame. If an expedited hearing is requested, what can the hearing officer do? Rule number 12. A hearing officer may order the return of the child to the placement from which the child was removed, or order a change of placement to an appropriate interim alternative educational setting for not more than 45 school days. In conducting this expedited hearing and making a determination, the IDEA provides that the hearing officer may order a change of placement of the child with a disability. Specifically, the hearing officer may either return the child to the placement from which the child was removed or order a change of placement of the child to an appropriate interim alternative educational setting, often called an IAES, for not more than 45 school days, if the hearing officer determines that maintaining the current placement of the child is substantially likely to result in injury to the child or to others. So, if a hearing is requested, does stay put immediately kick in? Rule number 13. When a hearing is initiated, the student remains in the interim alternative educational setting pending the expedited decision of the hearing officer, or until the expiration of a placement change, whichever occurs first, unless, of course, the parents and the agency agree otherwise. The 2004 IDEA significantly changed the stay put provision by allowing the LEA to keep the student in a changed placement pending a hearing request. Specifically, the IDEA provides that when an appeal, and the law calls it an appeal, has been requested by either the parent or the LEA, the child must remain in the interim alternative educational setting pending the decision of the hearing officer, or until the expiration of the time period for which a change in placement exceeded 10 school days, whichever occurs first, unless the parent and the agency agree otherwise. The law prior to the 2004 IDEA provided that stay put generally kicked in whenever a hearing was requested, and that the LEA then had to seek an expedited hearing itself or seek a temporary restraining order from a judge to keep the student from immediately returning to the current placement. This was a big change and has in general eliminated the immediate need for a school system to seek a TRO or other such relief when a hearing is requested in the disciplinary context. Okay, with these 13 rules in mind, let's now apply some of them to the hypothetical that was presented at the beginning of this video dealing with the two students who were caught smoking marijuana in the boys' room. Can the principal immediately remove the student with a disability from school? Yes. As far as disciplinary action that can be taken, the principal can immediately remove the student from the middle school and place him in an interim alternative setting for 45 school days without regard to manifestation or those other procedural hoops. Keep in mind, though, that the student's IEP team could also meet and determine that a longer change of placement, let's say for a year, would be appropriate for the student. Either way, the principal, without an IEP meeting, can go ahead and move the student for up to 45 school days to an interim alternative setting, and the manifestation determination and the FUBA and the BIP stuff could come later. Next question, can the student be further suspended from school? And if so, what procedures must be followed? Well, since the illegal use of drugs was involved, removal to the 45-day alternative placement would be the first course of action, of course, rather than further suspension or expulsion. However, if further suspension or expulsion were recommended as appropriate, remember that a determination would need to be made as to whether the total of those 20 previous days of suspension in conjunction with further suspension in the school year would amount to a change of placement. Because that may not be clear depending upon the pattern of those removals, it would probably be wise to ensure that any further suspension or an ultimate expulsion is made through the change of placement procedures under the IDEA. Obviously, this would then require a meeting of the IEP team to jump through those procedural hoops to make an appropriate manifestation determination, and if no manifestation is found, propose further exclusion from school beyond the 20 days he's already received. However, the student would still need to be provided some services. If manifestation is found, however, no further suspension would be allowed, and the IEP team would also be required to conduct the FUBA, prepare a BIP to address the drug-related behaviors. In any event, the student could remain in the interim alternative setting for the 45 school days. Next question. Does the previous bus suspension and the in-school suspension affect the principal's ability to further suspend the special education student? Well, the answer to this one is clear. It depends. According to the U.S. Department of Education, an in-school suspension is not considered a part of the days of suspension toward a change of placement, as long as the child is afforded the opportunity to continue to appropriately participate in the general curriculum, continue to receive services specified on the child's IEP, and continue to participate with non-disabled children to the extent they would have in their current placement. With respect to the bus suspension, the USDOE has commented that whether a bus suspension would count as a day of suspension would depend on whether the bus transportation is a part of the child's IEP. If the bus transportation is a part of the child's IEP, a bus suspension would be treated as a suspension unless the public agency provides the bus service in some other way. Where the bus transportation is not a part of the child's IEP, it's not a suspension. However, public agencies should consider whether behavior on the bus is similar to behavior in the classroom that's addressed in the IEP, and whether the child's behavior on the bus should be addressed in the IEP or in a behavior intervention plan. So, whether the student's suspension on the bus must be considered in determining whether a change of placement occurs will depend upon whether transportation was on his IEP. Finally, was the IDEA violated when the assistant principal called the police? No. The IDEA specifically provides that nothing would prohibit an agency from reporting a crime committed by a child with a disability to appropriate authorities or prevent state law enforcement and judicial authorities from exercising their responsibilities with regard to the application of federal and state law to crimes committed by a child with a disability. Thus, the assistant principal was well within his authority to report the child's criminal behavior.
Okay, so I know that was a lot of information. It sounded like Susan had told me that maybe the video and the voice were a little bit lagged from where I'm at, but this will be posted tomorrow, so you can always go in and re-watch this video. It does have some really good information in it. So some additional things. So just so you know, there is a Google document that we are asking you to fill out, and it is the confirmation that you viewed or joined this live webinar. So you can either view, that you viewed it after, if you watched it again, or that you joined it. There are 2 simple questions on it. We need you to answer those because we have to submit it to the state for the documentation that we conducted a training in regard to discipline. That form must be completed by April 10th. And if you would like further training information for your school about discipline or MDRs or anything about the above, please feel free to reach out to Susan or I. We're happy to help. So some other quick reminders. Our face-to-face meeting is April 25th. We'll begin promptly at 9 and we will end at 1. So remember, we are not providing lunch. We'll have coffee in the morning for you all, and be looking next week at a special newsletter for information on exactly what you should bring. There have been some questions about who you should bring. So you want to bring someone who can help you or works with you in determining data and what to do with that data. April 29th, I will be completely unavailable for calls or anything. We have a CATE audit that will be happening. So if you have an emergency, email or text me, or if you can't get me, of course, I will volunteer Susan. You could always reach out to her. Just as a reminder, ESY meetings must be held by May 17th. So I know it seems like that's a long time away, but I mean, we're already going into almost we're in the first week of April. So before we know it, it'll be the end of May. So just keep that in mind. You need to hold your ESY meetings by May 17th. The other thing some of you will be getting is that fun COSIF report, our preschool outcomes. So the state allowed us to do a pre-submission this year and look at our data ahead of time before we actually have to submit it to them. So we do have some things we need to fix. Remember, COSIF is filled out for children who are turning 6 and they have had at least 6 months of service prior to their 6th birthday. You must do an exit form. Students who leave your building or your school, even if they're not 6 and of that age, do an exit form. As students enter your program 5 and under, get an entry form or do an entry form. As students move in under age 6, if you can't get that entry data from the previous school district, complete one. Be sure that you are looking at the entry data if completing exit data. We see in a lot of situations, we have students who did great upon entry, but then all of a sudden their scores were awful when they exit us. I don't think that's necessarily true. I think we're not looking at the entry data. We shouldn't have students that are regressing because we've given them service. Don't just randomly pick their ratings. If a student has left and exited your school and been ended in Enrich, please let me know and I can reactivate those children so you can complete the COSIF. This will be coming out next week to those schools who it applies to, and in the email you'll get information about when it's due and what you'll need to do. So I'm going to stop sharing my screen and go back to your questions. Are there any other questions? Can you send this link out? So the link will be in the webinar. And you can feel free, Heidi, or anyone, to share that with your administrators or whoever you want. It's great information. We actually got this done in under an hour, so that was good. Susan, do you have anything to add or to this?
No, I think we need to reiterate that if there are students with behavioral issues or needing behavior support, please reach out to Laura and I, because even just reviewing IEPs, seeing students that are eligible for as other health impaired due to ADHD may have 10 accommodations listed, but there is nothing, for like inattentiveness, off track, things like that, but there's no goals that represent any of those things, even though that they are OHI. So it kind of correlates with the same message of having that streamlined behavior identified throughout an IEP process. And then if there's an MDR, then you're revisiting all of that. And I think, I think Laura, I can speak for Laura too, but in reviewing those IEPs and reaching out and giving individual feedback, some of that is being addressed.
Yeah, I agree. So like I said, I know the sound was a little bit lagged. I'm out here in Trenton, South Carolina, so it just could be the location. Do we do entry if they are 5 years, 8 months, but had had service of 6? No, Brock, you would not do entry then. If they are 5 years, 8 months, and they haven't had 6 months of service, then no. Remember, for COSIF, they have to have had at least 6 months of service. Any other questions? If you have questions about COSIF as the information goes out to you, you can always reach out to Susan or I.
Or Laura.
Or me, because I think Susan hasn't had to deal with COSIF very much. So you could reach out to me and I'll walk you through it. Or Laura.
I love how I just pass off stuff on to Laura.
Just email me or call me. The spreadsheet will be very clear on which student it is and what needs to be done. And some of it may just be a reminder that, hey, you need to do an exit by the end of the year. So some of it's going to be to remind you when you hold annual reviews to do them. Those are the things we always forget to do. Any other questions for the grade of the good? I feel like going Bueller. Okay, so I'm not seeing any questions pop in, so y'all must be, this just must have been fabulous for you. So just remember, this will be posted on the website tomorrow morning. I get it this afternoon, but I have to drive home from where I'm at right now. So we will get it posted by tomorrow. Make sure you go on and you fill out that Google document to let us know that you watched us.
Laura, when did we say, you and I had talked about it, when did we say it has to be done by?
It was in there April 10th.
April 10th? Oh, I missed that. Sorry. Okay.
Susan didn't have her listening ears on today.
I was.
It has to be done by April 10th. So we'll expect, tell your friends, your coordinator friends who haven't watched it, hey, you got to watch this. On April 10th, we'll be checking. And if you haven't filled out a form, we're coming after you. Just kidding. We'll send you a nice, gentle reminder. I'm just kidding.
We'll show up at your doorstep.
Yeah. So Susan will. If y'all haven't had your spring break, have a fabulous spring break. Enjoy. Enjoy time with your family and relax. Susan and I will be here working behind the scenes as always. And give us a call or shoot us an email if you need anything. But if not, we will see you guys all in a few weeks on the 25th.
Bye, everybody.
Oh, Tiffany said if she wants you to visit, she doesn't fill out the form.
Oh, I'm coming after you, Tiffany.
She's coming after you. All right, y'all. I'm going to stop recording here.